Good evening, everyone, and welcome to our September GAE Writes at Night. Thank you all for being here. While we welcome all public school employees, this event is only for GAE members and GAE staff. Therefore, if you are not a GAE member or part of GAE staff, please sign in putting your name, personal email address, cell phone number, and school system in the chat to me, Lisa Morgan. We appreciate your interest in GAE. We hope you will join our organization today by visiting joingae.org. Everyone, please note that you must receive prior permission from the GAE Executive Committee or the GAE Executive Director before recording audio or video in any form, including AI transcription of this meeting. Social media posts concerning this meeting shall not contain information about the specific content of the meeting, although the sharing of general information about GAE and GAE events is encouraged. Please be courteous to other attendees and request their permission before posting photographs containing their images. If you have questions about social media posting of GAE events, please contact the GAE Executive Committee or the GAE Executive Director at 678-837-1100. Again, so glad everyone is here today. And at this point, I will turn our proceedings over to our General Counsel for GAE, Mike McGonigal. Mike?
Thanks, Lisa. I will start sharing my screen. If I can find it. So tonight, Writes at Night is captioned or titled Frequently Asked Questions, but given that something just happened here. What? My screen went blank. Let's see. Okay, I have two screens. What can you see, Lisa?
I see your title slide, just the slide, what we want to see.
All right, good enough. That's what I want. So frequently asked questions, but in light of developments on the national front, given the untimely death of Charlie Kirk and all the online postings that have gone on, there's a real intersection of public employee off-duty free speech rights. And so I want to spend quite a bit of time in this session reviewing the do's and the don'ts, provide some helpful tips to protect yourself and the association. So what I normally do, I start off with this slide, just a review in case you encounter a potential member and you want to explain the advantages of the NEA GAE Legal Services Program. And so there's two main components here. One is the employment liability protection, and our coverages of a $3 million aggregate claim of liability coverage is greater than our competitors, and the same with the amount of attorney's fees that are that can be claimed in a membership year, that more than our competitors. But the number of lawsuits that the employee liability protection covers, the number of those suits I can count on one hand in a year. So they are unfortunate, but they are not common. The more common situation is the employment and certification defense. Okay, that's the vast bulk of the cases that come in to GAE Legal Services. And one of the important things to know about it is that our competitors have a cap on the amount of attorney's fees they expend on behalf of a member. So for example, if a competitor's member has an employment case and a certification case, they will cap those two cases, they'll combine them and cap them at $20,000. We don't have a predetermined cap on what we expend in defense of members. And you just don't know if you're going to be in a situation where you're going to have, say, an employment case, certification, a criminal defense case, and potentially even, a lawsuit. And that's the other advantage of our program under NEA GA is that we file affirmative lawsuits against school districts in appropriate cases. And obviously, we're not a personal injury firm. And, but we are very selective in the kind of cases we bring. But that is something that other organizations don't do. So just keep those points in mind when you're discussing potential benefits of GAE NEA with a member that you're trying to sign up. And there are many other reasons, other benefits to joining, but I'm just focusing in on legal services. So, and I also then want to spend just a couple minutes, couple slides on our history. And I've been doing this a number of years, but we need to be mindful of our history more than ever today with the shenanigans that are going on coming from Washington, trying to stamp out authentic history, teaching truth, essentially trying to erase Black history from museums and monuments, army bases, you name it, national parks. There's just some real problems with the way the direction the nation's going. So with that, you can read the slide. History is not just, dates, but that is a pretty succinct chronology of our founders. The white organization founded in 1867, right after the Civil War, and the GTNEA, the African American or Black Association, founded in 1878, or right at the end of Reconstruction, when the Union pulled out of the South and the Reconstruction came to an end. And that is when the GTNEA held their first meeting in Atlanta to come together and organize and chart a future for, at that time, it was Black education. It was segregated education, but that's the story of those founders, the GTNEA. And of course, we fast forward to the 54 decision, Brown versus Board of Education, a magisterial decision, probably one of the best that our country has ever generated, saying separate but equal is inherently unequal. And so that meant not just the South, but in the North, where segregation, wherever it existed, we had to desegregate and integrate our public institutions. In our case, about 10 years after the first Brown decision, the NEA adopted a resolution 64-12, stating that all of the Southern former Confederate states, they had dual associations, Black and white, that they must desegregate by 1966. And so, so started the discussions in the South and in here in Georgia between the two organizations, which eventually became the merger of the modern GA as we know it. Those votes were taken in, I believe, 1969, and then the merger was approved by the DeKalb County Superior Court in 1970, and the same day or the day after, the merger papers went up to the Georgia Secretary of State, and you can go to the Secretary of State's office and look at the original, merger documents that were filed with them, Secretary of State in 1970. So, oh yes, if you want to take a photo of these GA history resources, the first two books there by Professor Vanessa Siddlebacher, the first one about Horace Tate. Dr. Tate was GAE's first African-American executive director. And that book tells the story of his leadership in gaining equal access to resources for the Black schools here in Georgia. It's a fascinating story, and it's highly, highly recommended. And it gets into the merger debates and discussions back and forth of whether or not we should merge and all the rest of it. So there's good hunks of that book are devoted to the merger. And the second book, Hello Professor, that's about another GA member, Ulysses Bias, and Dr. Bias. This particular book talks about his successes in segregated Gainesville, Georgia public schools and what he did to gain equal access to the Black schools there that he was the principal of, to make them as good, if not better than, the white schools in Gainesville, Georgia. So it's another really eye-opening book as to what Black educators had to go through and fight for to gain equal access to resources so that Black school children could lead successful lives and be informed citizens and intelligent voters. And the last one there, The Organized Resistance of Black Educators, again by Walker. That is an academic paper. And from that paper is where I learned about GTEA founder Richard R. Wright. And that photographs from 1890 to 91. And in that paper by Walker, Organized Resistance, she says that unquestionably Richard R. Wright Sr. Called the first meeting of the GTEA in 1878 to chart the future for Black education here in Georgia. And, Mr. Wright, he was born in Dalton in a cabin in slavery. So he spent his youth in slavery. And after the Civil War, he became the first president of a land grant college that Georgia had to provide to get readmitted to the Union. And it was the Georgia State Industrial College for Colored Youth, which eventually became Savannah State. And it's interesting, when he started the industrial college, it was with 5 staff and 8 students. So starting off small, and by the time he left, he had over 500 students. And then it segued into Savannah State. He went on to move to Philadelphia, Pennsylvania, and become a highly successful banker there. And he established the nation's first Black Bankers National Association. So I say all that. He is one of our founders. I find him to be a great inspiration, a personal inspiration, a professional inspiration. And I encourage you to, take some time to Google him and learn up on Mr. Wright. And I hope you find him inspiring as well. So now turning over to what I, came up with, educator speech in the wake of political violence. And I want to, we're going through some, do's and don'ts and ins and outs and what courts are looking for when they look at First Amendment cases dealing with controversial speech. So the first lesson here, or the takeaway, is don't use the school computer to, even whether you're posting about political events or anything regarding your personal work or your personal life. There's this, you need to keep your personal life separate. You don't use a school computer for personal business. That's pretty obvious. And we'll get into the second aspect here, where I write, even on matters of public concern, do not condone, commend, comment on, or celebrate the death or violence expressed or implied. And we'll get into some of these posts, which are, you might say something fairly innocent, but you don't know how it's going to land or how it's going to impact people that you don't know. So you need to be, very careful with the language these days, particularly surrounding the death of Mr. Kirk and the MAGA movement, I guess I would say, in general, because they are looking to dox public employees, even for innocent speech that's protected. And obviously, when posting at any time, we don't use foul language or slurs or anything that's going to address your own personal grievances that you may have against, say, Mr. Kirk or others associated with him, because again, there are groups out there, organized groups that are looking for such information, and you can be doxxed, and we do have members in that situation today. So this is from the Minnesota affiliate. They sent around this little think first. I don't know where they came up with it, but I think it's just helpful when you send an email, or you're going to go on Instagram or TikTok or Facebook. Think first. So it's the acronym. Is it true? And how do you evaluate the truthfulness of what you're about to post? Do you have firsthand information, or is this gossip and hearsay? So you want to, think first. Is it true? Is it helpful? Are we, helpful in the sense of having constructive dialogue, without the slurs, without the attacks, without saying, oh, Mr. Kirk was full of hate. He had a lot of hateful language. He was a racist, and all those things can be true. But at the same time, what we've been learning in the past couple of weeks, that we need to be more constructive, have constructive dialogue. So is it helpful? H. What about inspiring? What are we, inspiring? We are public school educators, and we'll see in some other slides, that's going to be part of the court's analysis. Who are we and what is our role? Are we trying to inspire a constructive vision of the future, or where we should be heading as a nation? Inspiring speech. Am I going to say, is it really necessary? In my own writing, I will write something and look at it, and I will probably chop the first half of the sentence off, because it's really not really adding to the meaning of a sentence. So I am always asking myself, is that really necessary or not? And then lastly, is it kind? Are we kind? I think that's something we're, forgetting or is getting lost these days. Are we being kind to one another? Are we recognizing we might have a disagreement, but it's how we disagree, and are we extending, kindness to others that we may disagree with? I think that's the general thrust of this acronym, think first method, before posting online. So these are some of the elements that courts are going to be looking at in lawsuits. If you've been terminated, disciplined, even a letter of reprimand for a post, the lawyer language is going to say very fact specific, context specific of the language that was used, when it was used, and the courts would, they break it out this way. What's the importance of the issue? Okay. Are we just simply criticizing a political view? I disagree with so-and-so. Or are we expressly or impliedly celebrating or endorsing the death or violence of Mr. Kirk in this example? Court's going to look at time, place, and manner of the speech. There's what was it? Is it a private conversation I'm having with another down the hall in the staff lounge, or is it in a private text message between me and a colleague? Or was it on the public side of Facebook where the whole world can see it? So a court is going to be looking at the time and place and manner of the speech very carefully to determine whether or not the government could impose discipline. And there's a famous US Supreme Court case of a number of years ago where a public employee 1 said to public employee 2, during the time of the attempted assassination of President Reagan, something to the effect, well, if they try it again, I hope they get them. And the employee was let go. And one of the considerations that the U.S. Supreme Court looked at was, well, it was a private conversation between two people. And they took that into consideration in evaluating all of the evidence and said that no, that person could not be terminated or let go on the basis of a very short private conversation about, political violence. So that's something that they're going to be looking at. The nature of the employee's job. So what courts are saying, if you're directly responsible for a safe and supportive educational environment for all students, so that's most closely tied to classroom teachers and administrators, then your posting, if it's controversial, will likely be unprotected. And I put in their custodial staff in the sense that, yeah, I believe they are role models, that kids are always looking at all school employees, including custodial staff, as adults, as role models, as people that they can trust and be trusted around kids. But I don't know of any cases of a custodial staff being disciplined for posting things on the internet in this regard. But I'm just wondering, if a case came along, how a court is going to be looking at the nature of the custodian's function in a public school. But definitely, we know plenty of law out there about teachers being directly tied to legally providing a safe and supportive educational environment for all students. Okay, the other thing courts are going to look at, so it seems a little vague there, but that's what they look at: the effect of workplace discipline and harmony. So kind of gets to our feelings being hurt here, or did my online posting, my speech, undermine supervisory authority? Does the administration now, have I strained the relationship with administration? Can they trust me? Do they have confidence in me? You're supposed to have close working relationships with your administrators and colleagues. How do they view you now? So that's another element of what the court is going to be looking at in online free speech cases. And this one is really one that I'm really grappling with, is the level of public outcry, the heckler's veto. So the heckler's veto is basically illegal. What a heckler's veto is, you have a speaker come to your school and they're going to speak about a controversial issue, and the audience is going to be so offended that the government vetoes that speaker, even though they're speaking on protected speech grounds. They are going to be vetoed from speaking, canceled from speaking. And so, but what this does these days, and this is it's fascinating, but I don't think anybody has the right answer or knows where we're going. But this is rewarding the cancelers and the doxers. We have a situation where somebody posted something regarding the death of Mr. Kirk, pretty much not endorsing his death or anything, but it attracted extreme right-wing anonymous doxers. That's where I'm getting more conversant and educated on this phenomenon about how they scrape the internet looking for anything remotely controversial, and then going straight to the employer, the superintendent's office, the phone calls, the emails to the superintendent, saying fire Mike because he's endorsing the death of Mr. Kirk, which I really hadn't. but that's the way it comes across to extremists. And then it gets to, well, what is the level? And it shouldn't be this way, because I think in certain instances we're going to see people being disciplined for what would normally be protected speech, but for the level of public outcry and the volume of the cancelers, the volume of the cancelers, if they speak often enough and loud enough, that will have an impact. And right or wrong, that's how these cases are shaping up right now. And it's anyone's guess where we're going, but that's why I want to spend time, this evening about, let's be very mindful and very careful about how we exercise our right of free speech off duty on our own free time. So, and then this is the other big one, really is tied to the heckler's veto and the doxers, is the nature of the employer's evidence of disruption. So they can't just come into a court or a school board hearing and say, well, we've been getting complaints and I'm predicting it's going to disrupt the school. I'm predicting it. Well, the question is going to be, what is your prediction based on? You just can't pull it out of the air and say, well, look what they're doing. These doctors are saying, these extremists are saying, Mike's a horrible person, and how can I work with Mike? Well, the fact is they're going to have to show evidence that the potential discipline or termination or whatever it is we're talking about is based on credible evidence of a sufficient quantity that it provides a reasonable belief of a potential. So they can't just say it's a potential, but they have to have credible evidence to base a reasonable belief of potential disruption at school. And we'll see in a few slides a really obvious example of what disruption is based on some Facebook posts. But I'm not aware of any, really any pending federal court cases dealing with online suits where we've gotten into the discovery phase of the litigation, where school districts have to prove disruption to the work environment, because I know there are cases, and I'm dealing with one where it's the doxers are the disruptors, not the member. I mean, the member said what they said, but it was met with, overwhelming, like a tsunami of these extremists trying to get this educator fired. So long way to go. So we're not going to move into a few slides on social media, and this is borrowed from another presentation. And you can read the slide. I invite you to go to the Pew Research website, and it's just full of statistics that they collect. It's very helpful to understand the technology and social media landscape. Everybody's familiar with it, but if you're writing a paper for graduate school or something, on this topic, I would use Pew Research as a resource. Should go without saying, nothing's private and nothing's permanently deleted. There's that Snapchat. You probably know more about it than me, but it's, they dissolve within minutes, these Snapchat postings. But what people don't know is those posts from Snapchat, they are still embedded in memory, and the company keeps them, the deleted snaps, on its servers for at least 30 days. And I haven't been involved in any litigation where we've gone after Snapchat, but it's something to keep in mind, that nothing's private, nothing is permanently deleted. In other litigation that we fund through GA, we have gone after and have obtained personal text messages from superintendents and school board members trying in our race discrimination cases of South Georgia, and they can't run, they can't hide. The stuff's not deleted, and it's a very useful source of evidence. There are several state laws governing the internet and social media. The first one deals with deleting data. So if you delete data, depending on what it is, you might be committing a crime by deleting data. So you should be sure of what you're deleting. Identity fraud prohibits the using computers to encourage terroristic acts or promote harassing phone calls. Okay. The next one prohibits, let's see, what is that? Terroristic threats, right? We got that. Those first three there, I have actually used in cease and desist letters to extremist parents and extremist citizens in various parts of the state when they are posting horrible, awful, vile, false statements about members, calling in one instance, calling I think English teacher pedophile, a groomer, should be jailed for grooming, all because she had young adult books in her classroom, which had a sign posted, parental permission required. She followed every rule there was that the school district had, and the school district supported her, this educator, and yet these extremists were trying to get her fired. And I used those first three bullets there. They were clearly illegal. They could have been prosecuted criminally, and of course, civilly as well for defamation of character. These are just some of the online federal statutes that safeguard the children's privacy and internet safety. And FERPA, everyone's favorite acronym, Family and Educational Rights and Privacy Act. So those are just federal statutes to be aware of. And if you had a moment, you could, cut and paste, put them in Google or your AI chat, and you'll be up to speed on that. Some other things, again, to be really mindful of, especially in today's climate. These, the who, what, where, when, and why. That's I source from the Professional Standards Commission from their website. I find them to be, again, really useful. Hold the mirror up, and look at yourself. Who am I as an educator? What's my role at school and in the community, right? Remember, the more community, I guess, outrage about my posting could lead me into an area where a court would find that my speech is not protected. So not only my role at school, but in my relationship with the community that pays my salary. So what? And so again, what am I saying to the other person? Is it appropriate or professional? And where? This gets to the previous discussion. Is this a one-on-one verbal conversation, or is it one-on-one texting situation? Or am I on, TikTok with no unrestrained, unrestricted Instagram where the whole world can see it, and the extremists will, be getting a hold of that? Is it, day or night? A court's going to look at that. If it's during the day, was it during work hours? Well, what we talked about earlier, don't be conducting personal business during work time. And then why? Why am I doing this in the first place? It gets back to the THINK acronym. Am I being helpful? Am I being kind? What's my motive? And so I'm just sharing these because we have to be extra mindful these days, given the political climate. When we get into PSC investigations regarding social media, obviously you can see the list there. That's half of the standards out of 10 that can be implicated in a social media complaint there, whether you're saying something inappropriate or you're disclosing confidential information. Those are the two areas that I see. In fact, just today, I had 2 cases come in of inappropriate sharing of private student information. So we will work through that with the member. So our off-duty speech, this has been tonight's theme. And can we be discharged or disciplined for off-duty speech? And it's really a case-by-case basis. And so the freedom of speech is not absolute. I mean, we just need to reinforce that. And it doesn't give us the right, excuse me, to say whatever we want, whenever we want, or to whomever we want. We have our other freedoms of religion, press, and association, and petition. But it's important to keep in mind, yes, we have rights off duty, but they're not absolute. So we get into where our strongest protections are for off-duty speech as a public employee. And some of you have seen the presentation before. The slide is familiar. The speech is the strongest only to the extent that you are speaking as a private citizen on matters of public concern. So during the workday, virtually impossible to conceive of a scenario where you're speaking as a private citizen. So we're generally talking about after hours social media activities or going to your local board of education and speaking on a matter of public concern, like raising salaries, lowering class sizes, providing duty-free lunch for folks, or what are we going to do to protect? What is the board going to do to protect us with the the onslaught of doxing activities, or I'm trying to think of gun safety is another major issue, right? We had a horrible shooting in Oconee County at Appalachia High. Well, folks went to board meetings and said, hey, citizens and employees, what are you going to do to protect us? We need it. That's speaking as a private citizen on a matter of public concern, 100% protected under the First Amendment. And when you speak, you definitely layer on your statuses as a citizen, as a taxpayer, as a voter. If you're a parent, grandparent, aunt, or uncle, you should put those on in addition to, I am a member of the NEA, GAE, and the DeKalb Organization of DeKalb Educators. I am also a citizen and taxpayer, a voter, registered voter in DeKalb County. Layered on my statuses, more protection for me. And we're constantly saying, we're a union, so utilize your local association or your local union to speak collectively. I spend innumerable hours on the phone with members who are being unjustly and unfairly treated, and it may not be a legal issue, but they want to take on the school district all by themselves for some unfairness that's going on at school. And I always have to just sort of reel them back and say, look, you're not alone. You're part of a union. You're part of a collective. I exist through you. I am because of you. I am because we are. And it's more of a collective ethic versus an individual ethic. So speak collectively. And also reach out to your local community groups and have them, your PTA, your PTO, and your local churches are more than willing to come and support public educators more than ever, I think, because we are certainly under attack from many different angles. So public employee speech, okay, not protected. If you have a duty, if you speak and it's a part of your job duty to speak, the U.S. Supreme Court ruled about a decade ago that the federal Constitution will not protect that speech. And that case came out of Los Angeles Police Department, where an assistant district attorney blew the whistle on the police department having a ticket fixing scheme. So he's blowing the whistle on illegal cop activities. He was discharged for that. He sues, saying, well, I was blowing the whistle. And among his claims was that that's a protected speech under the U.S. Constitution. And so that went all the way up to the U.S. Supreme Court, and they ruled, to me, it's mind-blowing. They said, well, you had a duty to report that anyway. It's part of your job. So don't look to the U.S. Constitution for any protection. And they said, and here's the theme, and I'm sure it's familiar to everybody on this call. Don't look to the federal government for help. The Supreme Court is saying, look to your states. Look to in this case came out of California. Look to your California state constitution and look for your state whistleblower laws for protection. But don't be coming to us if that's part of your job duty is to report some illegal activity. So I mean, it really, it's part of this trend of reverting to states' rights and just simply the retraction of the protections that we've used to have from the federal government. Well, and also if your speech will not be protected if it deals on private personnel matters. So again, if I go to the local board of education and I'm speaking as speaking as a citizen, but my speech, the content of my speech is going to be complaining about the bad evaluation I got, and you should fire Principal McGonigal because he is a bad principal. That's not protected speech. I could be written up for that, for being, unprofessional, for example, because it's not dealing with a matter of public concern. It's a matter of private personnel matters, not protected. So then we get down to the disruption. And then the next slide, we'll look at Atwater versus Tucker. Atwater was the superintendent of Tift County Schools at the time, and Tucker was a middle grades teacher in Tifton Middle. And the next slide we'll get into what the disruption was there, even if her speech is on a matter of public concern. But that last bullet is that if your speech is untrue or false, it's defamatory. It's like the example I had before of these extremists posting online that our member teacher is a pedophile and that she's grooming the kids because she has young adult books in her classroom, even though they required parental permission. That's false. That's defamation. And I let them have it, and they took down their post. They did. They didn't like it, and there's more to the story, but they're not bothering her anymore. Tell you what. What other rights do I have before we get to the Atwater case? Well, on your own time in your personal capacity, you can definitely write letters to the editor. Just be sure they're on matters of public concern. The safe areas would be, we need to fund education, adequately fund more resources, lower our class sizes, right? That's a huge one. If my school district has waived the duty-free lunch law, dear editors, the school board should amend their agreement with the state to not waive a very necessary law like having class size limitations or duty-free lunch rights should be restored. Those are matters of public concern. You can engage in political activity, marches, rallies, and protests, just like always. You can attend political fundraisers. Of course, we do that through GAE and our locals. Some of our locals do that as well for state representative races, state senate races, and local school board races. You can sign petitions. Just be really careful of what those petitions say. If you have any questions, send them to me, and I will vet them for you and say whether it's going to be a problematic petition, or not. Always, we don't want to inflame, but we want to inform. some petition writers sort of err over on the inflammatory side when you need to say, no, we just need to inform the public and the school board of the problem and the issue in a constructive, positive resolution. So here's the example of the disruption. So the case involved a middle school teacher in Tifton who went on her Facebook account, unrestricted, unregulated, and started commenting on BLM marchers in the holiday parade in Tifton a number of years ago, like 2015, 16. But she caused a disruption. She wasn't doxxed. She was none of those things. But on the Facebook page, on her own unrestricted, unregulated Facebook page, she was addressing the BLM marchers. And so some of what she said, I won't read it all, but it's all very offensive and racist. But she thinks, I think the BLM signs should read, take the hood off your head, comma, and pull up your dang pants, comma, and quit impregnating everybody. And those are in all caps. And I'm tired of paying for these sorry expletive deleted thugs. So, and she goes on, and this, is out there in public view, gets to in the African-American community in Tifton, and they start blowing up the superintendent's phone and his emails and saying, I'm pulling my student out of Miss Tucker's class because of her racist comments. I don't want my student. Can I trust her now? I didn't know she had this side. Is she going to treat my son or daughter fairly now? Now that I know that she has these vile and racist thoughts running through her brain, it was really quite disruptive. So she got a 5-day suspension and had to take some diversity training. But she sued the school district saying, I had a right to that, express my opinion. I was acting as a private citizen on a matter of public concern. And people can disagree with what she said about BLM marchers, but it was a matter of public concern. But it caused a disruption, and that's what the court said. Lady, we appreciate, you're being a private citizen speaking on a matter of public concern, but you really hurt the community. You hurt the students. You let them down, and you really, kind of got off light there with the 5-day suspension and diversity training. But they did not say that speech was protected because of the level of disruption it caused at school. And interestingly enough, last week, I didn't know this, but these lawyers appealed it from the Georgia Court of Appeals to the Georgia Supreme Court. Georgia Supreme Court denied a hearing. And so when that happens, they filed for a writ of certiorari with the U.S. Supreme Court. And I didn't know that until last week. They went all the way to the U.S. Supreme Court. And I read the briefs. They're fascinating to say the least. But the U.S. Supreme Court took a vote, and they didn't even entertain this case. They weren't even going to entertain it. You can read into it that they believed that the Georgia Court of Appeals was correct, but they weren't going to waste the court's time further reviewing it. So here's some questions. Now that we've had all this, great information about First Amendment and our off-duty conduct. So if you participate in a weekend rally protesting police brutality, is that protected speech? The answer is yes. And as a matter of fact, we had a member who did participate in a weekend rally protesting. It was actually during Trump's first administration, protesting ICE raids back in his first term. And this member was arrested. And it was in the media. Got out there. It showed him getting, getting handcuffed, being led away, and all the rest. And it's during the summer months. Well, he gets back to school in August, and the principal pulls him aside and say, "Hey, I saw that you were in the news for getting arrested, and I'm going to write you up. Put this on your TEKS. Give you a 1 on your TEKS because you don't represent educators well in the community." And he goes, "Oh, okay." Well, he contacts us. Long story short, we gave this school district, happened to be Gwinnett, the opportunity to withdraw that TEKS evaluation out of his file, or at least the rating. I think it was the whole evaluation on the issue of unprofessionalism. A month went by, they never got back to us. So we just filed a federal lawsuit, arguing that you violated his First Amendment right of free speech, participating in a rally, completely protected. And in less than a month, the school didn't even bother answering the lawsuit. They did the analysis and they said, yes, that principal was wrong. And so we settled that case even before it barely got in the courthouse door, didn't even get into discovery. Or 2, you post on your Facebook wall a local newspaper article favorable to a political candidate. Yes, that's protected. Again, remember the THINK acronym. Is it thoughtful? Is it helpful? Is it necessary? Am I promoting a positive vision, of the future? But that's protected. You write a letter to a publication that's critical of the school board for one of its actions or ideas. Yes, that is protected, as long as it's on a matter of public concern and is not a personal or private personnel matter. Number 4, you post a joke on Facebook that your students should be locked up. Well, that may be how you're feeling, but no, of course, that's an easy one. No, that's a no. You can be disciplined for that. Let's see, what's the last one? You're instructed not to discuss with your students your personal opinion on political matters. Okay, number 1, you've got a directive, okay? And the reason they would say don't discuss your personal opinion on political matters is that as a public employee, you're representing the government, and your personal opinions can be construed as the school district's position on a political issue or the government's position on a political issue. So you have a directive not to do it. Could be a concern, or it is a concern. So in a classroom discussion on racial issues in America, you tell your students that you recently participated in a BLM demonstration. Well, a lot of it's going to depend on, the evidence, the nature and quality of what was said, who initiated the discussion, what were your actual words, was it tape recorded, was it videotape? A lot of things go into that. What I think is more probably problematic, though, is you had a directive not to do it. And somehow there's a discussion where you say you participated in a BLM demonstration, and that's an expression of personal political opinion. So I don't have a clear black and white yes or no answer to that, but it's an example of something to be mindful of moving forward. So we spend a few minutes, we got a few minutes, Lisa. I want to go through a gripe or a grievance. I hope that's okay. Okay. So gripe or grievance, this is a sort of the daily life of legal services and our UNISERV directors across the state. When we get an email or a call from a member, this is a checklist. Is the issue you're talking about, is it trivial and minor, or is it a serious violation of a law, rule, or policy? Secondly, is it a personality conflict that's really driving the issue here? Is it just that superintendent or principal is jealous of the fact that I am, a PhD and they don't have one, and they're jealous. And so they're treating me with disrespect, but it's based on petty jealousy. So you have to think about that. Does a viable remedy exist? You know, I want them fired, Mike. I want them fired. That's a pretty common one. But what's a viable remedy here? And every situation is going to be different, but we have to think about what's real and what can they deliver on. And lastly, is the member serious about standing up for their rights? We sometimes members will come with a legitimate legal compliance issue, but they don't want to get involved. They just don't want to. They want to remain anonymous and send something to the school that we receive complaints, anonymous complaints about, say, lack of duty-free lunch or something like that. It again, we're a union. We you should be able to trust your union to have your back if you're going to file a grievance, because there are anti-retaliation protections in the grievance statute. So we'll have a grievance, but you got to be willing to stand up for your rights. What good are our rights if we don't actually use them, right, guys? So here's some situations. So gripe or grievance. My principal eats with the other teachers during lunch with her clique. Is that a gripe or a grievance? Well, I think it's pretty obvious. There's no law against eating lunch with the clique. If you're a new teacher, you might be that outsider. That would be a gripe. Okay. And I don't know what the remedy would be if we send something to the principal. 2, my supervisor always asks me for a specific reason when I apply for personal leave. What are the GA members think about that one? What do you think, President Morgan? Or anybody in
That's
the
a grievance.
That's right. And it's because there's a law 20-2-850 or 53 or 54 that prohibits your principal from asking for the reason for personal leave. They can't ask, and they certainly can't deny it when you don't give them a reason. All you got to do is check the box, personal leave, boom. That's it. That is a grievance. 3, I received an overall 20 on my annual TEKS, but the principal gave me a 2 on professionalism. Gripe or grievance? Well, I know the people that I have talked to are not happy with my take on the situation. I'd say that's a gripe. I mean, you got a 20, respond to the 2, and enjoy your summer. And when you come back July and August, do your pre-evaluation and get that all set up so you can show them who's boss in area professionalism. Or number 4, the department head is not doing his job. I want him fired, Mike. I want him fired. So, he goes off to professional development and he doesn't tell us, what happened there. I'm doing his work. I don't get the respect I'm due, and he doesn't say hi to me in the hallways, and he's often late to work. I want him fired. Well, tell you, that's probably going to, unless there's a clear-cut legal issue, that's going to be basically a gripe. That's going to be an organizing issue that the local association should be, thinking about and being assisted with the UNISERV director. There are ways to hold department heads or administrators accountable, but we don't have the ability to actually fire somebody. So what is, I think that's our last slide. So which of the following is a legal services scenario? Teacher calls upset. She's worried that she'll have to report a DUI arrest last Saturday night after the Georgia-Alabama football game. And that's coming up next, right? I think that's coming up this weekend. Well, okay, so the answer there is she she has a duty to report to her employer, the DUI, and a duty to report to the self-report to the Professional Standards Commission. Um, I won't get on my soapbox right now. I disagree with the reporting to the PSC, but um, she has to report to the PSC and the employer. Now, is it a legal services? Not necessarily. The UNISERV director can assist with reporting to the employer and self-reporting. They don't allow legal representation. I learned that a while ago where I tried to help a member self-report an arrest, and they said, no, we don't allow lawyers at that level. The member has to do it. So, okay. Two, a longtime member with 20 years classroom experience with the same school district received a notice of non-renewal signed by the superintendent via certified mail. Yeah, that is a legal services matter. That sounds like a non-renewal case under the Georgia Fair Dismissal Act. And I would hope that the UNISERV director would at least go to the superintendent or HR, have a discussion. Is there any way to, I don't know, put them on a PDP for next year, but just let's not go through the non-renewal process. But having said that, once an educator gets that letter, the clock is ticking on them to request a school board hearing within 10 days. So yeah, that would be a legal services matter. So three, the bus driver calls, and she says a parent videotapes her every day at the bus stop and posts the videos on social media. And that sounds familiar. The parents post claim the driver is grooming the children and wants her fired. I'd forgotten about this, but yeah, that actually happened. So going back to those previous slides towards the beginning, I had no choice. So I sent the parent a cease and desist letter saying, you committed defamation, you're illegally surveilling the bus driver, you're invading the privacy of these students, and you need to stop, cease and desist immediately, or a lawsuit may be filed against you. So we were successful in having that particular parent stand down. And the last one is the paraprofessional attempted to calm a disruptive student, yelling and waving his arms while seated at his desk. The desk falls over, the child is hurt. The paraprofessional has reported the defects, the PSC, and has just received the lawsuit. The triple whammy. So yes, by all means, come to legal services. We'll assign an attorney for the defects investigation, the PSC investigation, and we will file a claim to the liability insurance carrier. Remember on that very first slide, we have the employment liability protection up to $9 million liability protection. We assist members in filing those claims with the insurance carrier. So we will handle all three of those matters for the member. That's it.
Okay, Mike, we have one question. If you can provide us a quick answer. I think I know what you're going to say. So what if someone makes a fake profile pretending to be you? Fake profiles pop up all the time and post inflammatory messages on social media. How should our member handle that?
Well, that to me would be a cease and desist letter that I would need the contact information of that individual. And I need, all the screenshots and everything that is, defamatory, that you're claiming to be defamatory. And then once I have that information, I can compose a cease and desist letter, send it to that individual overnight mail, FedEx.
Okay. And so, like, I know what happens all the time is they create fake profiles and you don't know who's doing it. We should obviously report that to the social media company, whichever one it is, correct?
Yeah. So if you don't know, I haven't had that, but it's going to come because these doxers are anonymous. And my understanding, through the miracle of technology, the Southern Poverty Law Center also has some pretty sophisticated software where I might reach out to them if I had something like this to say, hey, what are you guys doing to determine the identity of these doxers? They have a lot of resources over there, so I'd be interested to follow up and learn the identity of these people and learn about the software.
Thank you. And thank you, Mike. Thank you all for joining us this evening. I know we went a little off what our original plan was this evening, but thought it was very important for all our members to have this information. So thank you all for joining us this evening, and everyone have a great rest of your evening.
Mm.